data as such to support that lack of data can be a prime reason for low conviction rate. That is not proved as such. And also the kind of measures that are being introduced, like the mass biometric surveillance that will be brought forward under this act, under the Criminal Procedure Identification Act, that is not very proportional to the kind of objectives that is being sought, as will be highlighted further in my presentation. For my research, I have depended upon qualitative research methods, and I have mainly focused on secondary data sources. So the concerns under the Criminal Procedure Identification Act are first that there is this forceful sharing of measurements. So in case of, there is no provision of taking consent from an individual before taking their measurements under the Act. In case a person refuses to share her measurements under the Act, that will constitute an offence under Section 186 of the Indian Penal Code. Secondly, there is no classification as such with respect to the severity and nature of offences under which measurements can be sought to be collected from an individual. A person who has committed a very minor traffic violation and a person who has committed murder, there is no differentiation as to what sort of measurements should be collected from each person. There is this blanket provision of collecting all forms of measurement: biometric, iris scans, fingerprints, biological samples, behavioral attributes. The only exception in this act is for biological samples, wherein a person has to have committed an offence against women and children for him to give his biological samples to the authorities. Otherwise, there is a concept of consent in this provision. However, for collection of behavioral attributes, there is no such exception. The third concern in this act is that the measurements that will be collected under this act will be stored in an electronic format for 75 years with the state instrumentalities. So this period of 75 years, it exceeds the life expectancy of an average Indian person in our country. Further, there is no provision as such that will lead to there is no provision that equips an individual to get his or her data deleted from the storage with NCRB. The only exception is for first-time offenders who have been absolutely acquitted or released without trial and discharged without trial, or have been acquitted by court after exhaustion of all legal remedies. So this provision of deletion of data from the records, this kind of assumes the availability and universality of access to legal aid for all individuals. When we say that a person's criminal record will be deleted from the database only if he has been acquitted after exhaustion of all legal remedies, we assume the fact that all legal remedies will be available to each and every person of our society, which is not true for the marginalized sections of the society who do not have access to quality legal aid in our prisons. Further, the measurements that are sought to be collected under this Act, they are going to be used for criminal profiling. As mentioned in the Act, the purposes for the collection and processing of data include prevention, detection, investigation and prosecution of any offence. However, the individuals from whom we are collecting this data, they are not necessarily criminals. Data can be collected from any person, as mentioned in Section 5 of the Act. Any person may be directed to share his or her measurements regardless of the severity of offence and regardless of his or her criminal history. This particular provision sets forward a bias, particularly if we look at our denotified tribes, such as the Padis in Madhya Pradesh, for example, and other denotified tribes in India, who are the first communities to be rounded up by the police in any locality whenever a crime is reported. These communities are already under the scanner of the police at a local level. Now, if this act is implemented and a person is rounded up from this community by the police, earlier when his data was being stored at a local level, now this data is going to be stored in an electronic format for 75 years at a centralized database. Further, the Act nowhere mentions any data protection principles or safeguards, despite collecting data that is of sensitive, personal, identifiable nature. So when I speak of information privacy, it basically means that a person An individual should have the right to control over his own personal data and should be able to execute and take decisions to the extent to which his personal data should be communicated to others. So the main principles that are identified under the concept of information privacy are consent, purpose limitation, data minimization, storage limitation, notice, right to erasure, right to rectification, etc. So we have seen that this act nowhere provides the concept of consent. Any person can be forced to share his or her measurements with the authorities, and if he fails and refuses to share his consent, share his measurements, then that will be classified as an offense, as a criminal offense. Further, there is no purpose limitation as such for each data, each set of measurements that is collected. While we know that overall these measurements are going to be used for the purpose of prosecution and investigation, the specific purpose of each set of measurements that is collected from an individual is not communicated to him or her. Thirdly, the principle of data minimization states that only that data should be collected from an individual that is absolutely required. However, there is no specification as such as to the severity of offense and the kind of measurements that can be collected from an individual with respect to the offense that he or she has committed. In fact, any measurement except for biological samples can be collected from a person regardless of his or her criminal history. So this act in general kind of contradicts the concept of fair trial in the criminal justice system, because when you collect measurements from a person regardless of his criminal history with the aim of creating a criminal profile, you automatically presume the existence of guilt in that person. There is a differentiation in this regard with respect to the creation of criminal profiles and the procedure of getting information deleted from the electronic database. That is extremely vague and discretionary. There is under the criminal procedure identification rules, Rule 5 provides for a nodal officer to be appointed by the government who can be approached with a request to delete the information from the database. However, that request is further recommended to the NCRD. So this entire procedure can be very complicated and vague and very unique for somebody outside of the system, especially for somebody from a marginalized community.
Diti, can I just ask you to wrap up, please?
Yes.
Time is up. Yeah.
Yes. Another concern is that there is no measure to rectify wrongful data entry. And a major concern in this regard is that when we see this law in the context of other laws, such as the Juvenile Justice Act of 2015, the Juvenile Justice Act provides for the principles of privacy, confidentiality, and fresh start. However, the Criminal Procedure Identification Act does not exempt juveniles specifically from this legislation. So when we forcefully collect measurements from a juvenile, a minor who might have committed a crime due to various socio-economic reasons, we take away his right to a fresh start in life. So these are my recommendations in this regard. The standard operating procedures that the NCRD will issue must include some data protection principles, and there should be an appointment of a grievance officer who can be approached directly by the individual with the request of rectification of data in case there is a wrong entry of data. And the detention period of measurements should be decreased from 75 years and fixed according to classification of offences based on severity. Juveniles should be exempted under the Act except for heinous cases. And the collection of measurements must be proportionate to the nature of offences. Officers in charge of collecting data must be trained in the process of digitization. And there should be training sessions to include the concepts of encryption and anonymization, since we are authorizing head constables and prison wards as well. And the right to consent and withdraw consent to share certain measurements like behavioral attributes should be included in case of less severe offences. So this was my research. Thank you very much.
Any questions for the presenter? Alright, in that case, I would like to reiterate that your presentation is for 10 minutes, where you will get a reminder just before 2 minutes. And on the discretion of the chair, you might get an extension of 5 minutes to end your presentation. Thank you. So the next participant here we have is Anamika Singh, Surbi Meshram, talking about unveiling the Criminal Procedure Identification Act 2022, a controversial act with loose ends. Over to you.
Good afternoon, everyone. I hope I'm audible.
Yes, you are.
Thank you. I'll be sharing my screen.
You can continue, I guess. You can continue.
Anamika, I want you to continue.
Ms. Surbi, can you please share the screen for me? Okay, so I'll be starting with my presentation. In the meantime, my colleague will share the screen with you. Okay. So good afternoon, everyone. Myself, Anamika Singh. Me and my co-author, Ms. Shah, are going to present our paper titled Unveiling Criminal Identification Movement Act 2022, a controversial act with loose ends. So our paper shall do a threefold analysis of the act. Firstly, we'll be focusing on the fact that this act is inviting abuse of power. Secondly, we'll be focusing on the fact that this leads to data protection breach and privacy breach. And thirdly, that it does not seek to achieve any legitimate purpose. Moving on to this next slide. So I'll be dealing with the first and third issue, while my co-author will be dealing with the second issue. So my first intention for abuse of power is that the mode of collection of data or the means through which the data is collected is not at all valid. Because Section 3 of the Amendment Act gives power to police authorities and prison authorities to collect the data. Now, these two are the very authorities that have been at various instances held accountable for abuse of their power. Now, to put the cherry on the top, Section 6 of the Act gives power to them to use force while collection of the data. As the statistics are visible on the figure, these are just the cases pending for custodial torture in the NHRC. And out of all these cases, only 6% lead to conviction. So this faces a serious concern when it comes specifically for the marginalized section, because neither they are aware of the rights nor they have means to protect them. And at this point, I would also like to cite Georgetown Law Report, which tells us that in America, where a similar national database is followed, where more than 50% of the American adults have ended up with their names in the police database. Now we are just hoping that this scenario does not get repeated in India. Now, as I have said that this collection of data is not proper, it obviously leads to my next contention, which is it is not at all reliable. Now, this Amendment Act gives the power to the authorities to retain the data for 75 years. Now, this measurement includes biological data as well. The amendment does not provide any kind of guidelines for preservation and storage of this data. Biological samples, if not kept properly, are susceptible to contamination and hence loses their accuracy after a point of time and hence become inaccurate. Now, I would also like to point out the fact that the body, that is NCRB, has been given power to collect the data. If we look at the historical background of NCRB, this was established just for, even the statistical figure of crime rate in India, and it is not equipped enough with the machineries to maintain DNA database. Now, if they are going to outsource this power to a private agency, it is obviously going to lead to a breach of privacy. Furthermore, I am contending the non-reliability of the data on the fact that the biometric measurements, which involve fingerprint and iris scanner, can be easily duped by simply wearing a latex glove or a colored pencil, for example. And this whole process can be used by the police to falsely implicate the prisoners, specifically those belonging to the marginalized section. Because all of this work is without any judicial scrutiny, therefore, there is a question on the reliability of the data. Now, since the data was not collected by valid means and the data cannot be relied upon, This raises obviously negative implications on the rights of the prisoners, starting with the right to privacy and bodily autonomy. As Article 21 confers this right to life and personal liberty, which can be curtailed only through procedures established by law, which in the present case is this Act. Now, for this Act, that it should curtail the right of privacy, it should be fair, reasonable, and be proportionate. But this Act fails to achieve all these three targets. Furthermore, the Act gives right of denial of collection of data only in limited cases, and it does not even prescribe for any limit, be it 1 year or 2 years, as was in the earlier Act. It does not prescribe any limit for collection of non-biological data in relation to denial of the right of denial. Now, this leads to a right of self-incrimination getting breached. Now, the right of privacy and right of self-incrimination has been provided under various international conventions as well, and this Act obviously fails to achieve the same. Moving to my third issue, that is, this Act fails to achieve any legitimate aim. To substantiate this, I would like to give a fourfold explanation. Firstly, that this Act fails to establish any legitimate intelligent differentia. Now, the thing is, Article 14 wants us that every law should have a reasonable justification, reasonable classification. Section 3 of the Act, the Amendment Act, gives power to the authorities to take samples from all arrested persons or the convicts under any law. Now, this brings juveniles also under the ambit of the Act. Furthermore, there is no intelligible differentia when it comes to petty offences or in relation to taking samples from maintenance of offenders convicted for maintenance of peace, breach of peace, or even for a very, very serious offence. So there is no intelligible differentia at all. Now, this leads to my second contention, that is, the Act is very vague in scope because it fails to define the basic elements, like what do you mean by analysis. The Act does not prescribe at all what will be the nexus between the measurement taken, how it will be analyzed, and how it will be further utilized for the investigation. It does not justify at all as to what these measurements are collected and how they will be limited in their distribution. Now, this takes to my next contention, which is this whole Act does not fix any kind of accountability or reliability on any particular authority. Section 4.d of the Act gives power to the NCRB to share and disseminate the record to the law enforcement agency without even defining what this law enforcement agency comprises of. So this puts our data at a very, very, very great risk. And this also takes to my next contention, which is the authority has been given unfettered power. Section 3 gives power of collection of data. Section 6 allows them to use force, and Section 8 gives them power to further delegate the whole rule-making process. Without any limitation on this power, this Act actually inviting the abuse and is not seeking to achieve any legitimate aim. As described by its preamble, it said that this Act is going to facilitate or ease the criminal investigation. When all these elements are present, it's not easing any kind of criminal investigation. Now, to further substantiate on the relation to privacy and data protection, my co-author will be doing it. Thank you.
Very warm good afternoon all the panelists, all the attendees of the session. Myself, Surmi Mishra, I'm an assistant professor of law at Symposium Law School, Hyderabad. I'm going to be continuing the topic, another topic of the paper, which is the data protection and privacy. And with respect to the data protection and privacy, what are the international commitment fields that we currently have? So we are heading towards, if we talk about the data protection and privacy, heading towards a data and technology-driven web of science, web of world, which curated data sets are listed. And then they are fed into algorithms. The objective of data security or data protection is to protect against the deliberate as well as any accidental loss or
2 minutes remaining.
But am I audible?
Yes, you are. Just wanted to say that it's just 2 minutes to go for your 10 minutes to go.
Can I expect to get another 5 minutes to wind up, like extra 5 minutes? Can I get it now?
Just not 5 minutes. Not 5 minutes.
In totality, you have less than 4 minutes to end your presentation. Thank you.
Right. So, talking about the present scenario, the regime that we currently do have with respect to data protection and data privacy, India doesn't have any comprehensive or specific legislation as of now on data protection. But there are certain guidelines on data protection which can be inferred from the Information Technology Act of 2000 as well as the rules attached along with that. And if we talk about the legal mechanism with respect to the data protection, with respect to the status of personal and non-personal data protection in India, it started from it stems from the time when the judgment of 9 judges constitutional bench of the Supreme Court. It came in the matter of Justice K.S. Puttaswamy versus Union of India, where in 2017 it was clearly declared that privacy lies at the core of the fundamental rights, which is guaranteed by Article 14, Article 15, Article 21 of the Constitution. And subsequently to that, in the year 2018, a 5 judges constitutional bench in the Supreme Court, they impressed upon the government to bring a very robust data with respect to the protection. In the year 2017, the government of India, it constituted a committee expert on data protection, which was chaired by Justice Sri Krishna. As well as after that, there was a discussion by the Parliamentary Joint Committee. We had the extensive hearing with respect to whether the personal data protection bill should also cover within its ambit non-personal data. So there were certain of the recommendations which were given by the Joint Parliamentary Committee on the Personal Data Protection Bill 2019 as of now. So talking about it, the Joint Parliamentary Committee posits certain of the things like inclusion of non-personal data as well in the PDP bill, as well as the committee also noted with respect to the bill that it does not have any provision to keep a check on the hardware manufacturers which collect the data from digital devices. So this committee's recommendation was also that the government should be making an effort to establish a mechanism for the formal certification process of all digital and IoT devices, whoever is collecting data, in order to ensure the integrity of all such devices with respect to the data security. Another of the recommendation was with respect to the availability of the technology, the cost, the practicability. If we talk about the individual's liberty, individual's right of privacy, therefore a regulatory body which is laid down under PDP bill, which is DPA, Data Protection Authority, which would be established under the proposed act. So if we talk about connecting the same to the international guidelines, talking about the same, we are adhered to Article 51 Clause C of the Indian Constitution, which forms part of DPSP, and it requires the state to endeavour to foster the respect for international law and treaty obligations. I would like to throw some light upon the international treaties and conventions that we have ratified, India have ratified. Coming to the point of European Union's GDPR, General Data Protection Regulation, there are certain breaches which we have done with respect to violations, and there are certain petitions which are filed in Delhi High Court as well as Madras High Court pertaining to the same, which we have quoted in the paper also. So basically the GDPR came into effect in year 2018, and in order to synchronize and establish a very compatible data protection and privacy regime, GDPR basically aimed to create the awareness of the significance of data among governments of EU. So Article 5 of GDPR, it enshrines that the personal data collection.
So Subi, can you hear me? Yeah. Subi, can you use your, so there's just 1 minute left. And it'll be better if you actually connect the issues on data protection to CCIA. So you can use the last 1 minute just on that, yeah.
Yes, I would like to conclude within 2 minutes, if you would allow.
I'm sorry, we are going to be over time, so just like last minute on your main points.
So basically, yes, coming to the point of conclusion and suggestions that we have put forth in our paper, there are certain suggestions that after talking all about UDHR, ICCPR, there are certain data breaches that have taken place in 21st century in void of data protection measures that we currently do have in India. There are certain of the suggestions that we have made. One is the execution of the Current Amendment Act should be stayed unless and until the DNA regulations are in place for proper DNA profiling of the prisoners. Another one is that a data protection law, a proper one, especially related to personal data, is to be brought, and the execution until that will be stayed. Changes, I think there are certain changes that can be brought with respect to the act. The term analysis is to be defined to restrict the purpose, as well as if we talk about the NCRB, the separate impartial body needs to be established for the collection and maintenance of data. And also, certain investment on research and development and continuous new innovations in technologies preventing the breaches of data. Certain learning outcomes after doing comparative analysis in the paper, what we have done is in UK, they have certain provisions with respect to separate safeguards with respect to intimate and non-intimate samples. So that can be adopted from there. Germany has adopted a provision and they have a rule for collection of data only in the cases of serious offences and
Thanks,
also in
Subi.
cases of habitual offenders.
Thank you.
From Germany and China, we can borrow the provision to use the retention of data only till it is required and not for
Subi. Hi. Yeah. We've got it. Thank you.
Any questions put forward to the presenter?
I just had one question on the final recommendation that you were making in terms of staying the implementation of the Act until there's a regulation for DNA profiling itself. Why single out DNA profiling in this? Why not? I mean, since the arguments that you're making in terms of privacy, etc., apply across the board for collection and databasing of all measurements, I just wanted to know the logic of limiting that suggestion only to having a regulation for DNA profiling.
Actually, if you look at our bills, in 2017 we had specifically a bill relating to DNA use and technology, which was withdrawn, tabled and withdrawn. Similarly, the personal and non-personal draft bill were also withdrawn. So we have recommended that at least we have guidelines in relation to that. So till those guidelines are implemented as a legislative framework, this act should be stayed.
No, I get that, but why just single out DNA? I mean, why not ask for a Data Protection Act for everything, right? For that to be in place, and until that time, the implementation of the Act to be stayed. I was just wondering why the kind of special treatment for DNA collection itself.
Ma'am, because DNA profiling, if we look at the history, it has the ability to have a unique identity of each and every person and compare it with already existing DNA database. So if we put it there, we already have guidelines, we have not yet implemented. So let's just stay our app till those guidelines are in place.
Okay.
Thank you, presenters. I would again request presenters to time themselves and not exceed the limit. Even after the discretion of the chair, we would like you to stick to the time and keep looking at the chat box. There's a alert there as well. The next presenter we have is Ankit Sinha and Akul Anmol, talking about identify the problem, issues with the Criminal Identification Act 2022 with special reference to right to be forgotten and AI surveillance technologies. Over to you. Presenters, in case of any difficulty, do let us know on the chat box.
Good afternoon everyone present. Ma'am, I'll just take 1 minute to share the screen and then I will continue.
Sure, thank you. Ankit, you can now begin.
Yes, am I able to, am I audible?
Yes, you are. And put your PPT on full screen, please.
Okay, Is my PPT not visible?
It is visible, but we want you to put it on full screen.
Okay. से देखो ना इसको FI से क्या होगा फंक्शन नहीं
You could just begin. Your time starts now. No extra time would be given.
Okay. So good morning everyone present over here. I am Ankit and I am going to and my topic is to identify the problem issue with the Criminal Procedure Identification Act 2022 with reference to right to be forgotten and artificial surveillance technology. Ma'am, am I audible?
Yes, you are.
Okay, thank you so much. So basically my paper will be dealing with two of the issues. Not particularly right to privacy, but one of the ingredient of right to privacy, that is right to be forgotten. Firstly, and secondly, the artificial intelligence, the surveillance through the artificial intelligence. To begin with, the introduction, or I would say the research problem of my paper is that with the commencement of this particular new act, the Criminal Procedure Identification Act, the scope of the earlier act are widened. Now, in what ways? Firstly, the data which are collected in this which is collected are firstly the facial recognitions or the DNA, etc. These are the data which would be included in the biological data which is being collected. Firstly. Secondly, the storation of these data has been it has been listed that it could even go up till the 75 years. Thirdly, not only the person those who are under the prison, but also the people those who are any person could be whose data means with the permission of the magistrate, any person could be compelled to keep these data. And the last one is that these data, whatever is being collected, these data would be used for the purpose of investigation. Now, the basic problem because of which I have written this research paper, it has three major concerns. Firstly, this particular Identification Act actually infringes the right to be forgotten. That is one of the facets of right to privacy. Secondly, the infrastructure that is of NCRB means still NCRB is the agency who would be collecting these data, but it has not upgraded itself. And at the same time, it has the lack of infrastructure and there is no privacy, particularly privacy agency, which could actually protect the data which is being collected under this act. So second is the problem with the infrastructure of the NCRB. And the third and the foremost issue which I would be raising in this particular paper is that when these data is fed in the artificial intelligence for the purpose of surveillance, then this would be this would fall in the this would result particularly in discrimination and would be biased against some communities or some people those who are belonging to a particular geographical area. So to begin with, the first one is right to be forgotten. Now, as already discussed, and we all know that the right to be forgotten was also discussed in the case of K.S. Swamy versus Union of India. Now, in that particular case, the right to be forgotten was recognized. Firstly. Secondly, the only bill or act which could actually protect the right to be forgotten of a person is the Data Protection and Privacy Act. But it is still a bill and it has not been passed in our country. Firstly. Now, secondly, even if it is passed, if it passes in the legislation and if it becomes an act in future, even then it has several concerns, and that is raised in my paper. The first and the foremost concern is that section 10 deals with the right to forgotten of that particular bill. But that particular bill only considers that if a person takes data in an illegal manner, firstly, or secondly, if they are compelling the person illegally to give the data, then that person has the right to be forgotten and they can compel the agency to erase that data. But at the same time, if the collection of data, is in a legal manner, then that person, and if that agency even then uses that data in some malified way, then that person is left up with no particular remedy to claim against that agency. So at the same time, even the data protection and privacy bill needs to be amended, where after the collection of that data, how that data needs to be used by the agency has to be confined enough so that the person has their right to be forgotten, preserved. Firstly. Secondly, the exploration of data is for 75 years. Now this 75 years, as per GDPR of European Union, the exploration must be for a limited period, firstly. And accuracy should be the foremost concern by collecting these data. Now, when we are talking about the accuracy, the first and foremost thing which I took into consideration while making the paper is that the DNA sampling. Now, in the case of K.S. Puttaswamy, it was provided that while collecting the DNA sample, the accuracy of DNA sampling is 99.7%, and it has error of 0.03%. And when we check this 0.03%, then today in today's scenario there are approx 5 lakh people those who are under the prison. That means even 17,000 people's data could be inaccurate when their DNA sample is being collected. So actually that will create a problematic investigation, and that will create a problem while investigation is being made, because the people whose DNA is inaccurately matched, their right would be violated. First. Now coming up to the second problem which I already pointed out, that the NCRB lacks with the infrastructural problem. Now in that particularly, basically the NCRB was being made to collect the data as per the Prisons Act 1920. Now it hasn't updated till date, and the new act has been passed. Before passing this act, when we look into the Privacy Act or the US Privacy Office Department, which exists in United States of America, this act and this agency was actually formulated in USA to protect the privacy of that data and to make the guidelines that how these data should be used by the agency. Now allowing the NCRB to collect the data, for example biological samples, DNA sampling, facial recognitions. Now the NCRB is not the competent authority actually to process this data, to destroy this data, and even to store this data for 25 years without failing the nature of that, without preserving the nature of that particular data. So it's very much required that we need a separate agency within NCRB or a separate private agency which actually looks upon the privacy concerns of that country. Now I would be yes. Now the major aspect of my paper is how this data could be used for artificial intelligence. Now to begin with, and the major concern in this is that artificial uses is basically a machine learning process, and in this machine formulates the algorithm themselves, and by formulating these algorithms means they form the algorithm through the data which has been fed, and they form their own algorithms, and there is less human intervention in it. Now in several countries which I would be giving example of, these particular artificial intelligence, when they were used for profiling of the criminals,
2 minutes remaining,
purpose, and when they were used to signify that what geographical areas are more prone where these offences could be committed, then these gave the biased results, and that would be further dealt in this paper. The first one I would be giving the example of Hungary, where the artificial intelligence is being used for the facial recognition. Means there was an app which recognized the facial recognition, and the name of that app was Home Quarantine app. So people were put into the surveillance even at their home, that whether they were completing the period of quarantine or not. So the surveillance system even entered the house of each and every person. Secondly, in the Ireland, this facial recognition was used in the CCTV cameras on road, where the people were identified that these people could be a criminal, and that actually infringes their right to privacy, because unnecessarily they were put into the questioning and they were scrutinized. Thirdly, even Article 5 of the Artificial Intelligence Act of European Union members have condemned this act, use of artificial intelligence on the ground that it is discriminatory and biased in nature. For that, I would be giving examples of USA. Where USA uses the Compass, which is a risk assessment artificial intelligence. Now, which actually shows that who are the people, those who are more prone to commit these criminal acts. It was shown through a research that 77% of people, those who were shown as a criminal, were belonging to the black community. That shows that the people, those who are marginalized, earlier they were marginalized, and that's why they were prone to commit offense. Now those people's data has been collected and they have been feeded to artificial intelligence, because of which the people, those who have the similar face recognition, they are being compared to be.
Ankit, your time's up.
Yes.
Ankit, yeah, can you just wrap up in like 2 minutes, please?
Yeah, definitely. I'll just wrap it up.
Better to come to the conclusion, please. Yeah.
So now I would be giving up the examples that how the artificial intelligence, if used in India for the purpose of investigation or for the purpose of profiling, then it could create a biased result. For example, if there are some people, those who the people of northeastern or the people of northern states or the people who belongs to a south state. Now these people have a similar kind of facial recognitions. Now if this facial recognition, if a particular person belonging to a particular geographical area are prone to commit some offences, if that facial recognition is fed into the artificial intelligence, then artificial intelligence is prone to give the result that is biased towards the person who are living in that geographical area. And even if the person who has a clean history, that he has never committed any offense, he could be made scrutinized under this purpose. So the data which is being collected under this act, Identification Act, if it is in future used for the artificial intelligence purpose for surveillance, it would create a discriminatory and biased results ultimately. And the last suggestions which I would be giving is that first of all, as I have already said, that data protection and the privacy bill must be passed before implementation of this act, with the proper amendment that even when the data is being collected, the use of that data, if it is misused, even then person should claim their right to protect against the agencies. Secondly, there is a need for proper guidelines, like we have a Privacy Act in United Nations. So the same kind of Privacy Act is required in India to protect the data which is being collected by NCR. The third is that we need a special department which actually deals with the privacy concerns of for the data which is being collected. And the last and the foremost one is that
Time's up, Ankit.
Yes.
Time's up. Any question? Any questions that ma'am would like to put forth?
Yeah. Ankit, so I wanted to ask, are you, given all of the concerns that you talked about with the use of AI, I agree with you that there are a lot of issues that have come out with the use of predictive policing software, a lot of research that's been published in European countries, in the US as well. So, but are you making a point that we shouldn't be using facial recognition, for instance, if we take FRT as the example here, that we shouldn't be using facial recognition at all, or that the way in which the framework of this act is, which is that it allows the use of these technologies for a wider range of people and allows it to be data based, is that where your concern rises? Do you see my point?
Indeed. The last point which I was going to take into consideration in the way forward was this only, that there is, we term it as a black box, means the algorithm on which artificial intelligence works is known as black box because they create their own results. So it is very much required that human intervention is very important at every stage wherever artificial intelligence is giving the result. So even if we are using artificial intelligence for the purpose of profiling or for the purpose of surveillance, human intervention is required. It's not only on the basis of the decision taken by the artificial intelligence that a person needs to be scrutinized. Even if artificial intelligence compels that person or identifies that person more prone to commit the offense, even then there must be a human intervention, there must be an agency or police should be trained like that, but they shouldn't directly question that person. Relatively, they must check the history of that person and then only scrutinize that person.
Okay, yeah, I'd suggest that you read more on this topic because you will find, and it's not as if AI systems are being built without human intervention, but I think there is a lot written out there which also shows the same issues with human intervention. That despite human intervention, you will not be able to resolve those issues because the same problems that you're speaking of AI systems having those inherent biases, because the people who've coded that AI system have those biases, that will obviously still remain even in the human intervention space. Anyway, just one more thing. What is the source that you have for the 99.7% accuracy of DNA profiling? Like, can you share that, please? I think we lost it. Anyway,
Ankit, can you hear us? He's left the meeting. Mark, can you move to the next presentation? So next up we have Mrs. Chitra Saxena Nagpal and Professor Anita Rao talking about the role of forensics in remolding the rule of law. Over to you.
Excuse me.
A very good afternoon to the esteemed chair and to the organizers for hosting this wonderful event. I would at the foremost like to apologize for the unavailability of my co-author who is on a flight as we speak. So with your permission, can I share my PPT?
Yes. Yes, ma'am.
Okay, just I'm having some issue with the
In case you are unable to present, alright, we can see your screen sharing.
alright.
Shall we begin your time?
Yeah, thank you so much.
Yeah.
So at the very outset, let me say that my research has mostly been qualitative, and usually I mostly have used secondary data sources. This paper is actually on a very simple theme that over a period of time, as we look at over the previous 2 centuries, there has been development in the field of forensics. And that has led to recognition of forensic science as a way of pinpointing certain criminal jurisdiction issues. And the courts have recognized the criminal of years. And they have incorporated it, either the legislature has brought it into its fold or through judicial decisions, the field of forensic science has found recognition in criminal jurisprudence. Alright? So, alright, I'm not able to scroll, but anyway, I would like to go on.
yeah, Chitra, go on. We have your presentation with us. Yeah.
Alright, thank you so much. Okay, so I would like to first start with saying that through my paper, I have looked at 3 to 4 major aspects. Firstly, how forensic science advanced over a period of time, such as anthropometrics, which is basically measurements of the body, how they were brought into criminal investigation. Then it was basically fingerprinting, DNA analysis, also Dr. Rudolph's techniques of conducting autopsies were also recognized by the judiciary. So over a period of time, these things have developed, have progressed, and law has taken into cognizance these developments. When it comes to India, mid 50s saw this boom where yes, because of growth of science and technology, there were instances where forensics was used and it was employed to either exonerate the accused or put them in prison. Now, also, if you see that has the advent of digital forensics, which is an advancement over other classic fields of forensic science and forensic medicine. Now, what I am trying to say in my paper is that there has always been a gap. The technology moves at a very fast pace, and law somehow has always been a little late in catching up. Now, when we look at whether it is even intellectual property rights or any field of law, there has always been a gap between technology and updated legislations. Now, even though now we have Criminal Procedure Identification Act 2020, and it does raise a lot of data privacy concerns, and but the point is that it is still, so keeping that aside, all the data privacy concerns and the surveillance sectors and all the fingerprinting and the DNA analysis and documentation aside, it is still a very small step in, if we have to consider how the field of forensic science is improving and developing over a period of time, and we still do not have enough recognition of the developments and the advancements of science. That being said, there have also been cases that people, jurists thought was some very credible piece of forensic evidence was later negated. Like Stephen Cheney's case, where, like the esteemed chair had mentioned about bite marks. So it was through research over a period of years later, it was determined that Stephen Cheney was not the person who was involved in either of those two of that couple. So, and then he was exonerated after spending 28 years in jail. Same way, there have been cases where initially people were of the opinion that this is a person who, the accused person is the person who actually committed the crime. But later, through more advancements in forensic science, it was realized that this is actually an innocent. So that also remains an issue. So now with this Criminal Procedure Identification Act and also the advancement of artificial intelligence, we need to make sure that there is some kind of synchronicity between the technology that is available to us and also the law that is enforced. Also keeping in mind the various other concerns which are coming up with the bringing into the 2022 Act. Now maybe my suggestion is that firstly we need to have some accreditation agency which has a kind of a control over the content of forensic evidence which is coming. Then there has to be some kind of regulating agency which looks into the data privacy aspect of it. Also, it has with artificial intelligence coming here, and it is now it's a known fact that it will sooner or later get incorporated into forensic evidence, forensic medicine, forensic science. We need to be sure that there is no inherent algorithm bias which is there, and we need to basically incorporate all these things and make up a robust and a fair system that does not does not exonerate the guilty, but at the same time does not have to be innocent. So this is, through my paper, this is what I am trying to do now. Still work in progress. I am still learning and growing as I am writing, and the full version I will be submitting soon. And I would leave the mic open to the chair in case ma'am wants to say something.
Hello, can you hear me?
Yes, I can.
I was wondering at how are you connecting it to the rule of law issues? Can you throw some light on that rule of law aspects of this legislation?
So yes, rule of law, as per my understanding, is how criminal jurisprudence has developed over the period of years, keeping in mind the advancements in forensic technology. So whether it is through judicial pronouncements or through even legislations, there has always been some update with the gradual development in the rule of forensic evidence. Now, whether it is, if you look at the 2022 Act, it is definitely bringing into the ambit more advanced ways of storing evidence, storing forensic evidence than the previous 1920 Act. So gradually, the rule of law is also being impacted as the forensic science is developing. But my humble submission is it is still not at par as it should be with the advancement of science, and there is a gap.
Any further questions for the participants?
Hi Chitra. I just wanted to ask you, so I mean I see that you're saying that yes, forensics has assisted in and has a role to play, an important role to play in the criminal justice system, but then we also know that forensic evidence can be flawed, and that science is ever evolving, and therefore we should be careful of that before we place reliance on forensic evidence. So, but where does that take us when we knowing these two almost contrary factors? I think that even the professor's question was going towards how would you, considering these two contradictory things, what point or what position are you taking with respect to CPIA, right? Do you think CPIA is a progression in the law in the right direction, or is this going to cause more trouble than benefit?
So, yes, ma'am. So I am of the view that yes, certain new legislations are required to keep up with the advent of technology. But at the same time, because it's a very tricky field, we need to be 100% sure that when we apply and execute this law, we are actually not causing greater harm than greater good. So this would require certain, you can say, certain recommendations to be brought into the picture. Like there has to be an accreditation agency, there has to be a national regulatory agency. Also, it has to be, it cannot be totally relied, science cannot not be totally relied upon as 100% correct, because things do change over a period of time. What was good earlier has been negated by further research over the period of years. So we need to, it is a very tricky area, and though we do need more further advancements in legislation, but there should always be a cross-check and a balance between bringing the technology more into the fold of law, but at the same time not letting go of the human factor or the human element. So it has to be a combination of both to come to the best outcome.
Okay, thank you.
Thank you so much. Over to the last participant, who is Shivangi Shivi, talking about the ethics of using facial recognition technology in law enforcement, balancing public safety and privacy concerns. Over to you.
Good afternoon, everyone. Am I audible?
Yeah, yes, you are.
Okay, thank you. Good afternoon, everyone. My name is Shivangi Shivi, and today I am going to present on topic the ethics of using facial recognition technology in law enforcement, balancing public safety and privacy concerns. So let me introduce what is facial recognition technology. So it refers to the use of software that can automatically identify individuals by analyzing their facial features through images or video captures. So this technology uses algorithms that analyze unique facial features such as the distance between the eyes, nose, mouth and other things to create a digital representation of a person's face. If we talk about the use of facial recognition technology in law enforcement, so the first one is to match images of suspects or person of interest with those who are stored in databases. The second one is to help in identifying and locate the suspects. The third one is to investigate crimes and potential threats to public safety as well for the surveillance and monitoring purpose. The second one is, so what are the importance of ethical consideration? Since my topic is the ethics of using facial recognition technology, so the importance is first the privacy and data protection. The facial recognition technology involves the collection and storage of biometric data, which can be sensitive and personal. Therefore, it is essential to ensure that these data is collected and secured in responsible manner to protect individual privacy. The second one is the bias and discrimination. So, facial recognition technology can be biased or inaccurate, leading to errors or discrimination against certain groups like women, children, or on the basis of racism. The third one is the human right. The use of facial recognition technology can have significant implications for human rights, including the right to privacy, freedom of expression, and freedom of assembly. If we talk about the pros and cons, the first one is to help to solve crime. So this technology assists law enforcement agency by identifying suspects and tracking their movement. It enhances public safety by identifying the potential threats. It saves times and resources as well. It gives accurate identification even in low light condition, or if someone is wearing mask, then also they can identify. These are the pros. If we talk about the cons, the first one is potential for false positive. Like facial recognition technology is not always accurate and can produce false positives sometimes, leading to innocent people being misidentified and subject to arrest. The second is the lack of regulation, which is in India we have a very limited regulation related to this technology. And the third one is invasion of privacy. It raises significant privacy concern as it allows law enforcement agency to track and monitor individual movement and activities without their consent. Last but not the least, the bias and discrimination, as it is less accurate when identifying people of color, women, and children. Now, what are the laws? So this is the use of facial recognition technology by law enforcement agency is a new concept, and there are currently limited laws related to it. However, there are some guidelines related to this. The first one is Right to Information Act 2005. This act provides for the right to access information held by public authorities, including law enforcement agencies, which is under Section 2, Clause J. The second one is Right to Information Act, the Information Technology Act 2000. This act provides legal framework for electronic transaction, including the use of biometric data in electronic authentication. The third is the Protection of Human Rights Act 1993, and this act provides for the establishment of human rights at the national as well as the state level, which have power to investigate violations of human rights by government agencies, including the law enforcement agency. This is mentioned under Section 12. Fourth one is the Indian Evidence Act 1872. So this act provides legal framework for the admissibility of evidence in court. It includes provisions governing the admissibility of scientific evidence, including biometric evidence obtained through facial recognition technology, and it is under Section 45 of the Indian Evidence Act. If we talk at the international level, then we have Universal Declaration of Human Rights. Now the question is, how to balance public safety and privacy concern when we are using the facial recognition technology. So the first way is to establish clear guidelines and regulation, limit on its use to protect individual privacy. Second, by the use facial recognition technology only when necessary, should not be used as a routine tool in law enforcement. And the third is to ensure accuracy and transparency. Now, I would like to conclude. The use of facial recognition technology in law enforcement requires a distinct and thoughtful approach that balances public safety and privacy concern by engaging the public, considering the broader societal implication, and with this ethical consideration. Thank you.
Shivangi, just can you elaborate more on how do we ensure more accuracy while using facial recognition? Because you mentioned in the cons that it has a possibility of false positive. So should we, if we know that we can get it wrong, then should we even use it?
Yes, ma'am. Ma'am, if we talk about the accuracy, so we have to check the data quality. There should not be any system error. There should be proper laws and regulation.
Okay.
These things should be we should consider.
Okay. Laws and regulation for what?
Sorry, ma'am.
Laws and regulation, proper laws and regulation towards?
Proper laws and regulation for the facial recognition technology in law enforcement.
Okay.
Thank you.
Thank you, participants. Now we come to the end of a successful session 1 on surveillance technology and privacy concerns. Just a second.
Ask the question.
If there are any further questions that the panel would like to ask the participants. Since there are no further questions, we come to the end of the session. Thank you everyone for being a part of this session and making it a fruitful event. Thank you so much. Thank you so much panel for being so patient and kind to be a part of this session throughout. Thank you so much.
Actually, there is a question asked to you in the chat.
Oh, okay, yeah. What is
It's not to you, it's just like a fact.
oh, that one. Oh, right. Yeah.
That's it. Thank you.
Thank you.
ऑनलाइन को चला जाएगा वो जा चुका है स्केड्यूल से
सेशन 3 और टाइम क्या
सेशन 3
I'll just text on the group.
अभी क्या बोल रहा है
2:30
ग्रुप से पहले पता चल रहा है 2:45
I've texted on the group now.
2:30 is
मुझे लग रहा है 2:30 is fine.
Post lunch time पे.
ऊपर Akash, please post in session 3 and 4. We are running late.
मैम टाइम
अभी कैसे बताओ यार, ये अभी ये लोग जाएंगे 2:30 ऑनवर्ड स्टार्ट करते हैं.
2:30 onwards लेते हैं.
तुम लोग लंच के लिए भी जाओगे ना, क्योंकि
Camera off करो.
It's done? How is it? Okay.
The lot of answers is so expected. The students need to listen through the question also. I just trying to get them to like challenge your proposition because it's based so much on secondary research.
But I see majorly, if you also notice, maximum of them are into descriptive
and
very
going to the
field.
Yeah, like to challenge why what is the implication of that? So, because you'll have like very good titles, but when we go back to what was my central argument, I think that methodology of let me work with a hypothesis and then let me research and build a central argument.
That is the reason now these people are going to the field. जैसे मैं किसी लोग के साथ ना मेरे को मेन उसको घुसाती हूँ. I tell them कि you talk to me very बहुत ही it's like some kind of a cocoon you are in, and you're staying and you're thinking